Okay. This is,
Did I put the wrong number on?
no, you just didn't finish. That's all right. Okay, so let me go. Are you Hallie Rawls? Will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Ms. Rawls, in cause number 25 DCCR 0623, let me pull up the wrong one. You're charged with the third-degree felony offense of possession of a controlled substance from May 30th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
In that case, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Rawls is not competent?
No, Your Honor.
All right, ma'am, in cause number 25 0623, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number 241987, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation January 27th, 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 13th, 20th, March 6th, 20th, and April 8th of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not provide verification of performing the community service as required. Is that true or not true? Count 4 alleges that you did not provide verification of completing the theft prevention class. Is that true or not true? Count 5 alleges you're behind in your court-assessed fees. Is that true or not true? And then count 6 alleges that you failed to complete a mental health evaluation. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have some documents in that case here on the computer that have your signature on them that the state's marked as Exhibit Number 1. Did you also sign and go over these with Mr. Rojas? And do you fully understand them? State tenders number 1.
No objection.
It's admitted. I'm going to find, Ms. Rawls, that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find that those counts true, again, that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These sentences will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. You can get that taken care of before. All right, are you Cody Dent?
Yes, ma'am.
And Mr. Dent has 2 motion to revoke probations in cause numbers 13-17772 and 22-41052. And there's a new offense, a burglary of a building, in cause number 250807. Mr. Samuel has filed a motion asking that I set a bond in those 2 MTRP cases. Is that correct?
Yes, Your Honor.
And let me get that pulled up.
As well as the motion for access to mental health expert.
That I probably don't even need to have a hearing. If you've filed the motion and there's,
Yes.
I'll look at it once if you'll just get it all filed with that attached to it. It needs to be e-filed. I'll take a look at it. It's no problem typically, as long as you have that affidavit of indigence attached.
Yes.
Okay, so. Oh, here it is. So are there no bonds set at the time?
Correct.
Okay. And are they deferred?
Yes.
They are both deferred. Mr. Smith, what is the state's position with regard to bonds?
I show on F-22 4105 it's a straight probation, 2 years, suspended for a period of 5 years.
Which one?
The second one, which would make sense if he got on probation after he was already on probation. Give me just a second. I want to take a look at the PC and that new offense, and then I'll let you put on any testimony you need. All right, I'm printing something. Do you wish to call a witness, Mr. Samuel?
Yes, I call Mr. Dent.
And you need to speak up so the court can hear, please.
Mr. Dent.
Mr. Dent, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. Go ahead, Mr. Samuel.
Yes, Mr. Dent, you were placed on probation initially in 2015, is that correct?
Yes, sir.
Okay, and since that time, you had one other charge that came up, is that correct?
Yes, sir.
Okay. Right now, are you presently under the care of any doctor facility?
It's been a time.
And are you presently on medications at this time?
Yes, sir.
Okay, and what medications are you?
Ooh. Don't make me lie. I don't know them by heart.
Okay, you live with, who do you live with?
My grandmother.
And you don't have any children, is that correct?
No, sir.
And your only source of income is from SSI?
Yes, sir.
Okay, and with that, now, going to the date in which you were last arrested, that was, when it says burglary of a building, that was a container, is that correct, at a business?
Yeah, well, I thought it was a Gibson dumpster.
Okay, just answer the question I asked you. Okay, it appeared to be a dumpster, is that correct?
Yes, sir.
You didn't think that was anything wrong with getting something out? You thought it was trash, is that correct?
Yes, sir.
Okay. At that time, had you had your medications?
No, I didn't take it immediately.
Okay. Your Honor, we believe that, I passed the witness, Your Honor.
Any questions with regard to this hearing?
No questions regarding this.
All right, give me a second. I'm reading the pre-sentence report, the PC.
Yes,
So it
ma'am.
shows that this was, the allegation is from theft at Discount Tire.
Right,
And there was a shipping container,
right.
and he was allegedly removing tires and placing them in his vehicle.
Right.
And this, the business apparently was closed, signs on the container.
and we will show the container, the signs. They somewhat obscure, but they were
Well,
there.
but they're on the business
Right.
property with tires that belong to Discount Tire Business.
Used, and the value of the tires were
Doesn't matter.
$50 a piece. I
Okay.
understand.
I guess I just want to make sure the problem is if we're having, okay. So the first probation was for obstruction or retaliation placed on that probation 2015
Correct.
for 5 years. I'm assuming that has been extended. And then while on that probation, there was a theft of property, was continued on the first probation, placed on probation in February of 2023 for a 5-year straight probation, and now we've got this.
Correct.
Okay, I think at this time, based on the nature of the underlying offenses and based on the allegation in the new offense, based on the fact that there are some obvious mental issues, I don't know that it's in the best interest of anyone for me to let Mr. Dent back out to be doing the same thing. It sounds like he's stabilized. I want to make sure he is. We can get an evaluation done. We'll get you an expert, and then we'll set it for a hearing. But I'm not going to grant the motion setting a bond. I don't think that is in the best interest of our community or Mr. Dent for that matter.
Why can I, excuse me, can I ask you something, Ms. West? Why can I not get a bond?
Because you're on 2 felony probations and the allegation is that you committed another felony offense.
I don't think there was a crime, taking some tires, getting some tires out of stuff.
Well, then that's a bigger problem. All right, you can go back with the bailiff.
I don't see that you filed an exam.
She said she got it this morning. I called her to make sure she had my secretary.
Oh, so she's following it now.
Yeah, you just.
Okay, thanks.
Your discovery certification?
I don't have it because I didn't expect to plead it. I will email it immediately.
Did you sign the,
Oh, yeah, I can do that part.
well, we need it today because if I'm going to sentence her, the case gets closed out and you won't be able to get it.
I'll email Judge too.
I'm gonna,
Okay.
as soon as I get to my computer, which is next to the work.
I'll email.
Okay, either way, yeah, just do it before she does the judgment because once that happens, I think the portal closes. All right, ma'am, you're Michelle Johnston. And Mr. West, will your client waive the formal reading of the indictment?
She will, Your Honor. Thank you.
And so we're going forward today with sentencing and everything?
Yes, Your Honor. Going forward, we're asking the court to give her credit for the time she served, the 15 months on the federal sentence, which was the time that she served was during the pendency of this case. In fact, at this time, I'd offer State's Exhibit number 1.
2.
No.
Make it number 2, please.
Which is information related to her
Federal sentence.
federal sentence. And for the record, she was indicted in the federal case in October of 2023, and then this case came along. October, she was pled and sentenced in the federal case in October of 2024, and this case had been pending, having been indicted in December of 2023.
So
Okay.
she started, does that have any objection to that?
No objection. Okay.
So that sentence there was for a 15-month sentence.
Yes, Your Honor.
And so it's y'all's intention that I give her that entire 15 months and that she not be required to go do any,
That's the intent of the parties, Judge.
That's what we want, Your Honor, yes.
I guess the issue becomes on these, because it was a federal sentence, that she has not technically been to and received a number from TDC, which is required in this case. And so but you don't have one on this case.
But when Jefferson County came and picked me up from feds and brought me to 69, and I was over there overnight, and so I got the bond the next day. So they gave me a number.
That's a show number.
So you have it,
Oh,
She has a TRN.
but she doesn't have a TDC.
Right. No, she's not going to TDC.
yeah, because I've never been to TDC.
I don't think I can just give credit and her not go through. I can give her the credit,
Right.
but she's going to have to go in and get a TDC number. It's my understanding. So let's do this. Obviously, if you have credit, we're not going to make you go anywhere today. So just,
She's working through it.
I understand what y'all are trying to do, and I'm not in disagreement with that, but legally I have to make sure
Okay.
that we do it in the right way, because if you don't have a TDC number, I don't think we can do it that way. The only thing that we could do on a state jail felony, if you want to give her, why don't y'all just do a 1244?
I'm okay with that, Judge.
That clears it all up,
I obviously don't have a problem with that, Your Honor.
because then she doesn't need,
She has an ATC number.
she's doing her time in our county jail.
She has enough credit for
I'm
that.
looking at y'all like y'all are going to help me figure this out.
I'm okay with that.
I think that makes it cleaner, because she doesn't necessarily,
I'm okay with that, Your Honor.
Yes.
I mean, it's the same result. Everybody
Yeah.
wants credit,
Right. It's still getting the conviction.
but it's still a state jail felony conviction, so she still needs a state, I'm thinking all this through, because she still needs a state.
And if need be, I'm okay with proceeding on this one.
That honestly makes it the most clean.
Just do a misdemeanor there,
12
sentence her to 12 months,
Yeah.
give her credit for the.
That helps, I think that makes it,
So we can get on down the road, Judge.
As far as
okay, I
convictions
appreciate
go,
that,
she has a
Mr.
federal
Coleman.
Conviction. That's the.
so let me, hold on a second, let me get this indictment, and we're going to go through I'm going to recall everything that I just did. We're going to kind of start over a little bit. You're good. This
You're
this
good.
makes it where you're going home and it's all taken care of, okay?
That's what we're trying to do, is there's some legalities that we have problems with, that she understands what we all want to do here.
When you get sentenced to state jail or TDC, you have to have a state jail or TDC number. You got to kind of go through that process and then get right back out, but it's not necessarily a quick process always. So this is going to be, with everyone's permission, can I make the modifications on the agreed punishment recommendations as well as the admonishments as to what we're doing?
No objection, Mr.
No objection from us, Your Honor.
So I'm going to change this. If I could figure it out. Okay, so let's go back. And in 23 DCCR 2260, the state is elected to proceed on the lesser included offense of a Class A misdemeanor theft from November 14th of 2020. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. West?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And what we've all worked through here is that the punishment would be for a 12-month term in the Jefferson County Jail. You will receive credit on that sentence for all of that time because you were in custody in, hold on, cause number, nope, that's not it. Where is it?
124-CR-32, Judge.
Thank you, Mr. Coleman. And that was a 15-month sentence in the federal system. And so I am giving you credit for all 12 months on this sentence. Is that everyone's understanding?
Yes, Your Honor.
Yes,
Please.
State tenders number 1,
No objection.
it's admitted. Also, I'm going to admit number 2 without objection.
No objection also.
All right. Is there any evidence that Ms. Johnson is not competent?
No, not, no, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of theft, sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail. Again, you receive credit on that sentence for all of the time that you were in custody on that federal case. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. It should be printing soon. Here's states. Who gets that? Do they get states too? Oh. You get that. You get that. Okay, thank you, ma'am. You're free to go. Thank you, Mr. West. Thank you, Mr. Coleman, for helping work that out. Thank you. And you'll get that, make sure and get that attachment emailed to the clerks today, please. All right, are you Shadamon Mitchell? And will your client waive the formal reading of the indictment?
She will.
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be or giving up any right to appeal?
Yes, sir.
And it looks like the agreement that you've reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution.
Yes, sir.
Okay. I'm
We're okay with it.
inclined to reduce that. I'd much rather the restitution. How old are you?
25.
Okay.
We're okay.
So the restitution would be $3,999.68. Is that your understanding?
Yes, sir.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There is not.
And is there any reason not to go forward today since y'all have the restitution amount?
She doesn't have a criminal history.
All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm sorry, did you just do something? I'm seeing movement. I thought so.
I'm sorry.
That's okay. I thought she needed something on your case. All right.
I'm so sorry.
No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand?
Yes.
So $4,000 is a lot of money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately, even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months, and all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation, and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again. I don't need...
I'm sorry.
I don't need to see your belly button in court,
Oh, yes, ma'am.
okay? You're in felony court. Dress appropriately. That's important. It's time to kind of grow up. You're on a felony probation. You need to do things in an adult way, and dressing like that is not an adult way to show up to court. Okay? You need to have a seat here in the courtroom. Probation's going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay? Good luck to you, ma'am. Thank you, Mr. Comerford.
We are winding down on this. We got an offer since our last court date.
Okay.
It has $80,000 in restitution. So what we're asking the court is give us a little bit more time to vet that, the proof of services for that, and see if there's something that we could come up with up front to help resolve the case. I looked and couldn't find them. I did find though the proof of services for that $80,000, so we need to go through it. He has
Okay.
not seen it. That was added in discovery at a later date than when he came to my office the first time.
Okay. Any issue?
No, if you recall, when we first came in here, we were still waiting for.
Right.
Because the cleanup was still.
Right. And so y'all got everything's here, you've got it all? Okay.
The offer's been sent, we should be.
Perfect.
Done today.
So we'll do one more reset, and Mr. Rucker, make sure you go in, visit with Mr. Galmore, go over all of that discovery so that we can figure out an announcement at your next court date, which direction your case is going to take. Okay? All right. Thank you. Are we? Okay. Your Karis Antoine, and this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge. And we contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoppower call because he's used to dealing with them.
Right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
To
along.
reiterate what said, I spoke to them by email, Stephanie.
Okay.
But we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me
expect
an
them?
update, but it was Friday.
Okay.
I got last contact.
She's usually pretty responsive. All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record, I'll show you their the email.
Good morning, Mr. Rojas.
Morning, Your
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He would, Your Honor.
Are we going on count one? Oh, no?
No, ma'am.
Okay.
Everything.
Okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999, and after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge,
do we just need to...
This is the turning point when the defendant officially pleads guilty in criminal court. This moment locks in consequences, and from here on the judge focuses only on sentencing and legal formalities. Notice how the judge explains immigration consequences. This is critical. Many defendants don't realize a guilty plea can affect their entire future, including deportation or denial of citizenship. And just like that, a court accepts the plea, the judge confirms competency and evidence, which legally seals the conviction. From this point forward, the outcome becomes unavoidable. Now things get more serious. A motion to revoke probation means the defendant already had a second chance, and the court is now reviewing whether that chance was violated. Listen carefully. Each true response confirms a violation. These admissions stack up quickly, making it almost impossible for the defendant to avoid jail time. Here comes the final blow another sentence. Added, even though the terms run concurrently, this moment highlights how multiple cases can compound into serious legal consequences. Do you think the punishment is fair?